So a lot of people mistakenly believe that birthright citizenship is so obvious that surely the plaintiffs here have to win. That Trump's executive order, this executive order on birthright citizenship, clearly, it's obviously unconstitutional. It is so obviously unconstitutional. How can anyone question it? Like this account says, birthright citizenship is in the plain text in the Constitution. See also U.S. v. Wong Kim Arc, which is an 1898 Supreme Court decision that touches on the question of birthright citizenship. And many people believe this. Many people believe birthrights. Everyone knows birthright citizenship is the truth, is the law. It's in the plain text of the 14th Amendment, isn't it? And I can tell you, as an American citizen who's lived here most of my life, except when I've been occasionally overseas for a time or two, I also believed, I have been told my entire life that if someone's born on U.S. soil, they're an American citizen. The problem is, it's a lie. It's a complete and utter lie. That's not what the law says, and it's not what the 14th Amendment says. And only an extremely superficial understanding of the 14th Amendment could lead someone to that conclusion. Now, of course, there are powerful forces for whom that conclusion is very important. It's really important to powerful people and institutions and agencies that the incorrect understanding be accepted as the law. The incorrect understanding being that anyone born on American soil, regardless of the nationality status of their parents, is automatically an American citizen. Certainly the Democrats need this because actual American citizens are no longer voting for them, are discarding the Democrat Party. That's why actual American citizens are being displaced by tens of millions of illegal migrant third world invaders. And of course, the Democrats want the babies those invaders have to also be counted as American citizens, even better than the illegal migrants. Now they're not just counted for purposes of House apportionment and electoral votes and how much federal funding a state receives, talking to you, California. But of course, the babies, if they're accepted as American citizens, also get to vote. A whole new generation of voters for Democrats, of purported American citizens. Unfortunately for this argument, that's not the law. Here is the relevant portion, the citizenship portion of the 14th Amendment. And if you just were to take kind of an idiot's view of it, it looks like maybe it does provide for so-called birthright citizenship. It says, all persons born or naturalized, but let's focus on born in the United States and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. Isn't that birthright citizenship, Andrew? It says right there, all persons born in the United States are citizens. Well, it does say that, but it doesn't just say that. And that's the problem. There's two conditions that have to be met, and they're separate conditions. Born in the U.S. and subject to the jurisdiction thereof. And jurisdiction thereof in this context means more than, for example, the criminal jurisdiction. Because this is not an amendment dealing with criminal law. This is an amendment dealing with political law, with citizenship. Obviously, everyone physically present in the U.S., whether you're a tourist or an invader or an American native Indian or here on a work permit or an American citizen, if you're physically present within the borders of the U.S., of course, you're subject to our criminal jurisdiction. But this means more than that. It has to be mean more than that, or we wouldn't need that phrase subject to the jurisdiction at all. Because you're automatically subject to criminal jurisdiction, for example, simply by being physically present. If you're born here, you're physically present. So, of course, by default, you're subject to the criminal jurisdiction. The only reason to include subject to the jurisdiction thereof as a separate clause from being physically present, from being born here, is that it means something different than merely being physically present. And in fact, it does mean something different. It means subject not merely to criminal jurisdiction, but to the political jurisdiction of the U.S., and more importantly, exclusively to the political jurisdiction of the U.S. And how do we know this? Because the men who wrote and debated and ratified the 14th Amendment explicitly told us that's what it meant. I'm going to show you a bunch of quotes here, and you'll see the font is kind of weird. This is actually imagery from the contemporaneous congressional record. When this question of the 14th Amendment citizenship clause was being debated, and I don't want to go through the whole document. It would take too long. I'm just going to ask you to trust me that, first of all, what I'm showing you is the argument among the senators. I don't identify a senator with every quote here. And also, take it on my word that there was no opposing argument. There was 100% consensus among every one of these senators debating and ratifying the 14th Amendment Citizenship Clause that this is what it meant. As examples, this senator, I do not presume that anyone will pretend to disguise the fact that the object of this citizenship section is simply to declare that freed Black slaves shall be citizens of the United States. Not invaders, not illegal migrants, not people unlawfully present within the U.S. The purpose of the 14th Amendment Citizenship Clause is exclusively to ensure that freed Black slaves who would otherwise be stateless were recognized as American citizens in the aftermath of the Civil War, which of course is when the 14th Amendment was ratified. Another senator here. This will not, of course, the 14th Amendment Citizenship Clause, include persons born in the U.S. who are foreigners, aliens who belong to the families of ambassadors or foreign ministers accredited to the government of the United States. Does not include people born in the U.S. who are foreigners. Now, you may be thinking, well, how are you a foreigner if you're born in the U.S.? Obviously, the contemporaneous senators believed you could be born in the U.S. and still be a foreigner. How would that happen? It happens because by default, you inherit the nationality of your parents. And if your parents are foreign nationals, you are a foreign national. You're born in the U.S., but you are a foreigner. A foreigner. Another senator. Indians, talking about Native American Indians, born within the limits of the United States. So they're born within the U.S., but who maintain tribal relations, so their political jurisdiction is not exclusive to the United States federal government. It's split, at least split, with their tribe, are not, in the sense of this 14th Amendment, born subject to the jurisdiction of the United States. If you have divided political loyalty, you maintain allegiance to a foreign government, a foreign nation. When your children are born in the U.S., they are not American citizens. They do not qualify under the 14th Amendment. By the way, Native Americans born in the U.S. today do qualify as American citizens, not under the 14th Amendment, but because in 1925, Congress passed a statute that specifically provided for citizenship for Native Americans born in the U.S. But the 14th Amendment doesn't do that, and there is no similar statute for illegal migrant third world invaders. Another senator. The provision is that, quote, all persons born in the United States and subject to the jurisdiction thereof are citizens, close quote. That means subject to the complete jurisdiction thereof. What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means. And of course, what they're talking about is the allegiance of the parents who give birth to this child born on American soil. Same senator. It cannot be said of any Native American Indian who owes allegiance, partial allegiance, if you please. I might have forgotten to click a couple of those. Sorry, I was quoting them. Partial allegiance, if you please, to some other government that he is subject to the jurisdiction of the United States. So a partial allegiance is not enough. It is only those persons who come completely within our jurisdiction, meaning political jurisdiction, who are subject to our laws that we think of as making citizens. Another one. I've already replied to the suggestion as to the Native American Indians being subject to our jurisdiction in the context of the 14th Amendment. They are not subject to our jurisdiction in the sense of owing allegiance solely to the United States. Now, all this amendment provides is that all persons born in the United States and not subject to some foreign power. For that, no doubt, is the meaning of the committee who've brought the matter before us shall be considered as citizens of the United States. Another senator. I concur entirely with the honorable senator from Illinois in holding that the word jurisdiction, as here employed, ought to be construed so as to imply a full and complete jurisdiction on the part of the United States. Certainly, gentlemen cannot contend that a Native American Indian belonging to a tribe, although born within the limits of a state, is subject to the full and complete jurisdiction. That question has long been adjudicated so far as the usage of the government is involved. Another, I understand the words here, subject to the jurisdiction of the United States, to mean fully and completely subject to the jurisdiction of the United States. In other words, the parent of the child has no divided loyalties. They are an American citizen. They are not a citizen of a foreign nation. And you might remember this comment says, oh, check out Wong Kim Arc. All right, Wong Kim Arc was a U.S. Supreme Court decision from 1898. It involved a Chinese national. His parents lived in the United States. He was born in the United States. The family took a trip back to China. And on their return to the U.S., his parents were allowed back into the U.S., but he was not. His parents had permanent resident status in the U.S. They were permanently domiciled in the U.S. But he didn't have that status, Wong Kim Arc, the child. And the border officers said, well, your parents have a right to come in. They're permanent resident aliens. But you don't have that status, so you can't come in. And so he argued that I should be recognized as an American citizen. And the Supreme Court in Wong Kim Arc said, yes, you should be recognized as an American citizen. But their specific reasoning is important here. Whether the legal question before this court, Supreme Court case, whether a child born in the United States of parents who at the time of his birth were foreign nationals, but have a permanent domicile and residence in the United States, meaning they're making their life in the U.S. permanently. So they've made a permanent physical commitment to the U.S., and they are there lawfully. The U.S. government has a reciprocal acceptance of their presence. Children born to permanent resident aliens in the United States should be deemed American citizens. But this doesn't apply to illegal migrant third world invaders. It doesn't apply to people who are unlawfully in the U.S., to people who America has not accepted as permanent resident aliens in our nation. It doesn't apply to people who illegally cross the border. It doesn't apply to people who overstay their work visa, their student visa, their tourist visa. It doesn't apply to people who are in the process of applying for asylum status and then get their asylum request denied and no longer have lawful status. It doesn't apply to people who may have been let in, like the Haitians were let in because they turned their nation into a hellhole. And now that status is overturned and they're no longer lawfully in the U.S. And they were never intended, importantly, all these people on temporary visas, work, student, tourist, or on temporary asylum claims, none of them are permanently accepted as residents of the U.S. None of them are in the position of the parents of Wong Kim Arc. And so none of their children are in the position of Wong Kim Arc. So Wong Kim Arc is completely irrelevant as Supreme Court precedent for the illegal migrant third world invaders' children who happen to be born on American soil. By the way, I would argue Wong Kim Arc is bad law. Just 2 years before this decision, the same panel of Supreme Court justices issued the infamous Dred Scott decision that said blacks born in America were not American citizens. That was later overturned by the Supreme Court. So Supreme Courts, especially this one, makes bad decisions that have to be overturned. I would suggest that this was a decision that was expedient at the time when we had lots of Chinese immigrants in America and we were struggling with how to deal with them and their children, but it's not supported by the actual text of the 14th Amendment. 14th Amendment doesn't say that permanent resident aliens get some kind of exception. That's not in the 14th Amendment. So I think this is bad law. But even if you disagree and wish this to be good law, it still does not apply to illegal migrant third world invaders and their children. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.